The federal judicial system of the United States is currently defined by a period of profound structural friction, a systemic slowing of the gears that has pushed the legal timeline into a state of perpetual slippage. This is not merely a matter of political disagreement. It is a clinical observation of how procedural burdens, evidentiary requirements, and appellate remands have created a gravitational pull that is bringing the executive branch's agenda into a grinding halt. As we analyze the current docket, we see that the friction is not coming from one single source, but from a cumulative buildup of dozens of simultaneous challenges. From the One Big Beautiful Bill Act to the unilateral reinterpretation of the 14th Amendment, the federal courts have become a high-pressure laboratory where the limits of Article II authority are being tested against the rigid walls of the Administrative Procedure Act. Pay close attention, because what we are witnessing is the unfolding of a constitutional collision that offers no easy exit and no certain conclusion.
The epicenter of this procedural standoff is currently located in the chambers of U.S. District Judge James Boasberg. At issue is an investigation into whether senior administration officials, specifically Homeland Security Secretary Kristi Noem, knowingly and willfully disregarded a direct court order. The timeline is precise. In March 2025, Judge Boasberg issued an order halting the removal of hundreds of individuals to El Salvador under the rarely invoked 18th Century Alien Enemies Act. Despite this, reports emerged of 2 planes bound for the notorious Seacot megaprison. The friction escalated on November 19, 2025, when the D.C. Circuit Court of Appeals, while pausing parts of the probe, allowed Boasberg to continue investigating whether the administration's actions constituted criminal contempt. The testimony from Department of Justice officials has been startling. Drew Ensign, a Deputy Assistant Attorney General, was asked directly by Judge Boasberg if he understood the verbal order to turn the plane around. Ensign admitted he did, yet the planes continued their flight to El Salvador. This willful disregard has triggered a contempt inquiry that strikes at the heart of judicial authority. If the executive branch can simply ignore a judge's command while a plane is in midair, the very concept of a court-ordered stay becomes obsolete. The case, Noem v. Alotrolado, is now a ticking clock, with a hearing scheduled for the week after Thanksgiving that could lead to unprecedented sanctions against a sitting cabinet member.
While Judge Boasberg manages the immigration standoff, the U.S. Supreme Court has introduced a different kind of friction in the case of Department of State v. AIDS Vaccine Advocacy Coalition, AVAC. This case involves the pocket rescission of roughly $10.5 billion in appropriated aid funding, money that Congress authorized, but the president refused to spend. On September 26, 2025, the Supreme Court issued a stay that permitted the administration to unilaterally impound $4 billion of this funding just days before it was set to expire. The procedural maneuver used by the administration, transmitting a special message for rescission within 45 days of the fund's expiration, effectively bypasses the congressional power of the purse. In a stinging dissent, Justice Elena Kagan, joined by Justices Sotomayor and Jackson, warned that the stakes could not be higher. She argued that the majority's ruling allows the president to engage in a pocket rescission, allowing funds to expire without ever receiving the congressional approval required by the Impoundment Control Act of 1974. Kagan noted that this conflicts with the separation of powers, as it essentially grants the president the power to ignore future appropriations laws simply by timing their refusal to spend. This creates a systemic delay where billions in aid are frozen in a legal limbo, never reaching their intended recipients, while the courts debate the technicalities of the APA.
Perhaps no case represents the potential for constitutional recalibration more than Trump v. Barbara. The Supreme Court has agreed to hear this high-stakes challenge regarding birthright citizenship in its February 2026 sitting.
At the core is an executive order seeking to deny citizenship to children born in the U.S. to undocumented parents, a direct challenge to the plain language of the 14th Amendment. The procedural history of Barbara is a masterclass in judicial friction. Lower courts have uniformly blocked the order, citing over a century of precedent established in United States v. Wong Kim Ark. However, by agreeing to hear the case, the Supreme Court has signaled a willingness to entertain a re-evaluation of the citizenship clause. This has triggered an avalanche of amicus briefs and multi-state lawsuits led by Michigan Attorney General Dana Nessel and 20 other states. The timeline for this case ensures that the status of thousands of native-born American children will remain in a state of legal uncertainty until at least June 2026. This is the structural friction we speak of. Even when an order is blocked, the mere act of seeking a Supreme Court review creates a cloud of doubt that affects hospitals, social services, and families across the nation. The court's decision to schedule oral arguments for early 2026 ensures that the first half of the year will be dominated by this singular, existential question of identity. Simultaneously, the One Big Beautiful Bill Act, OBBBA, signed into law on July 4, 2025, has introduced a tidal wave of litigation that is currently clogging the federal dockets. The OBBBA implements over $1 trillion in cuts to social safety net programs, SNAP, Medicaid, and student loan services to fund $4.5 trillion in tax breaks. Attorneys generals, particularly Dana Nessel in Michigan and Letitia James in New York, have filed over 40 lawsuits challenging these cuts. The legal theory behind these challenges is unlawful impoundment and violation of the Administrative Procedure Act. The states argue that the administration is unilaterally stripping away healthcare and nutrition resources that Congress mandated. These cases, such as New York v. Kennedy, targeting HHS Secretary Robert F. Kennedy, Jr., focus on the mass termination of 10,000 federal health employees. The procedural burden here is immense. Each lawsuit requires thousands of pages of discovery, evidentiary hearings on irreparable harm, and months of briefings. The OBBBA has essentially created a litigation bottleneck where the federal government's ability to implement its budget is being fought inch by inch in district courts from Rhode Island to California. To understand the professional hazard currently facing officials like Kristi Noem or Pam Bondi, we must look back at the cautionary tale of Rudy Giuliani. The friction we see today, the willful disregard of court orders, was pioneered in the post-2020 election litigation. Giuliani's fall from America's mayor to a disbarred attorney who filed for bankruptcy serves as the structural warning for the current administration. The bar associations in New York and D.C. did not act because of Giuliani's politics. They acted because he made demonstrably false and misleading statements to courts. This created a lasting friction between the legal profession and the executive branch. Today, when we see 8 veteran career prosecutors resign from the DOJ rather than dismiss charges against Mayor Eric Adams, we are seeing the Giuliani effect. Legal professionals are increasingly unwilling to risk their licenses for executive mandates that appear to clash with the safety rails of the department. As former DOJ official John Tyrrell recently stated after being fired for training Pam Bondi on ethics, "These are not obstacles, these are safety rails, and you can't remove them."
Finally, we must address the looming conflict over the independence of the Federal Reserve and other agencies. In Trump v. Slaughter and Trump v. Cook, the Supreme Court is being asked to overturn 90 years of precedent established in Humphrey's executor. The administration's goal is clear: the unitary executive theory, which posits that the president must have the power to fire the head of any agency, including the Federal Reserve, without cause. Justice Kavanaugh has previously hinted at a re-evaluation,
of how we treat independent agencies. If the court rules that the president can fire the Fed chair at will, the structural friction between political cycles and economic stability will vanish, replaced by a centralized executive command. However, the path to this decision is fraught with procedural delays. The court has scheduled arguments for late January 2026, meaning the independence of the American economy hangs by a thread of judicial deliberation for the next several months.
As we conclude this analysis, the state of the federal government is one of intense, grinding friction. The Supreme Court has issued its warnings, the district judges have issued their ultimatums, and the appellate courts are struggling to keep up with the volume of emergency filings. Will the December 20th deadline for the Epstein files lead to the arrest of an FBI director? Will the 2026 birthright citizenship ruling redefine the American population? Will the OBBA survive the 40-state legal onslaught? The answers remain shrouded in procedural uncertainty. What we know for sure is that the rule of law is currently being tested by a structural friction that shows no signs of easing. The Verdict Watch USA will be here to track every motion, every stay, and every verdict. Subscribe to stay informed as we navigate the collision of the century. This is the watch that never ends.